Good morning, everyone. Good morning, Taran. So, hope you are doing well, all of you. And today we are here to discuss a case, Tofan Singh. The name is like literally very, rejuvenating. What happens when early in the morning when you come across such a case with such nomenclatures, Tofan Singh versus the state of Tamil Nadu? So good morning everyone, Zinia, Jazba, Soma Sundaram, good morning everyone, and everyone else, good morning. Okay, so Tofan Singh versus the state of Tamil Nadu. It's a criminal appeal number 152 of 2013, and the date of the case is 8th October 2013. Bench A.K. Patnaik and Justice A.K. Patnaik and Justice A.K. Sikri. Okay, now facts of the case. You must have come across Ndps Act, Narcotic Drugs and Psychotropic Substances Act, one of the stringent laws in the country, and perhaps a preventive detention law. And you know what is preventive detention law? Under Article 22, second part of the Article 22 of the Constitution deals with the preventive detention laws. Okay. Preventive detention laws are the laws, in which the investigating authorities are empowered to arrest the person on mere grounds of suspicion. Unlike the punitive detention laws, where after a person can be arrested only after a crime is committed. Okay. So preventive detention laws is like this, that Ndps Act is one of the stringent laws in the country, Narcotic Drugs and Psychotropic Substances Act. And under this act, the present case deals with this act. Facts. What are the facts of the case? Mr. L.S. Aruldos, NCB Intelligence Officer, NCB Narcotics Control Bureau Intelligence Officer, received information on 23rd October 2004 that a resident of Nanganallur, Chennai, namely Prem alias Kannan alias Sudeshwaran, was procuring narcotics from Guttu Singh, a Rajasthan resident, with the assistance of Bapu Lal from Chennai at about 9 p.m. Bapu Lal and Kannan were supposed to leave in a white Ambassador automobile, and when they arrived in Chennai, Kannan was supposed to transport the heroin to Sri Lanka. Okay, so you must have understood what was happening. There was a man named Prem, or you can call him Kannan, or you can call him Sudeshwaran. There are so many names like alias Kannan, alias Sudeshwaran, alias Prem. Okay. So this Kannan or alias Kannan or Prem or Sudeshwaran, whatever you call him, this Kannan was procuring narcotics from Guttu Singh. Guttu Singh was the resident of Rajasthan. Okay. And who was assisting such procurement? It was Bapu Lal, who was from Chennai. This Kannan was also from Chennai. He was the resident of Nanganallur, Chennai. Bapu Lal was also from Chennai, and Bapu Lal was assisting the procurement of narcotics from Guttu Singh. Okay. And then at what time they procured the narcotics? At 9 p.m. At about 9 p.m. they procured it. Bapu Lal and Kannan were supposed to leave in a white Ambassador automobile, and when they arrived in Chennai, Kannan was supposed to transport the heroin to Sri Lanka. Okay. They were supposed to leave in a white Ambassador automobile, and then when they arrived in Chennai, what was Kannan supposed to do? Like, the Kannan is the main person who is playing the most important role, because he's the person who has procured narcotics from Guttu Singh. Now he has come down to Chennai, and he's now going to transport or traffic the narcotics to Sri Lanka. Mr. L.S. Aruldos discussed the intelligence with his superiors and proceeded with the case after receiving a green signal. Okay, so Mr. Aruldos, when he received information, because it's very easy for the Narcotics Control Bureau to receive I'm sorry. It's very easy for the NCB, Narcotics Control Bureau, to procure such informations, because they are the intelligence agencies, and they have planted their spies at every location and at such places, and whoever is suspicious, according to the suspicious movements, they can track that person very easily and unearth all the informations of this kind. So Mr. L.S. Aruldos discussed the intelligence with his superiors and proceeded with the case after receiving a green signal. Now, his superiors said that you may go ahead with the investigation of the case. Mr. L.S. Aruldos, together with other cops, one sepoy and a driver, left for the area of the incident on October 24, 2004. So on October 24, 2004, Mr. L.S. Aruldos, who was the NCB intelligence officer, he, along with some other cops and one sepoy and a driver, they left for the area of the incident on October 24, 2004 and intercepted the aforementioned white ambassador car. There were a total of 6 passengers, 2 drivers and the appellant in the front, with Bapulal, Guddu Singh and Kannan in the back. Okay, there were a total of 6 passengers, 2 drivers, right? And the appellant in the front with Bapulal, Guddu Singh and Kannan in the back. There were 3 people sitting at the back and 3 in front. Okay, there was a driver, there was yet another driver beside him, and then there was the appellant Tofan Singh, who was sitting there in the car, and then Bapulal, Guddu Singh. Bapulal is the person who assisted the procurement of narcotics from Guddu Singh. Guddu Singh is the person who was the resident of Rajasthan. Don't forget these things. Okay, Guddu Singh was the president of Rajasthan, who was supplying the narcotics to Kannan. Okay, and Kannan was the resident of Chennai again, who was procuring narcotics from Guddu Singh with the assistance of Bapulal. Okay, now these 3 people, the main role players, they were sitting at the back. Following a police investigation, people at the back handed out a green bag containing 5 kg of heroin. Now, when the police initiated an investigation, people at the back, these 3 people, Bapulal, Guddu Singh and Kannan, they handed out a green bag containing 5 kg of heroin. They immediately it was a kind of a surrender. The drivers were permitted to leave. All the 2 drivers who were sitting in front, they were permitted to leave, but the remainder were all arrested for violating the Ndps Act. Remainder means the Tofan Singh, who was sitting in front, and the 3 people. That means 4 people in total were arrested. Remainder here is 4 people, because there were 2 drivers and the 2 drivers were made to leave. Okay, they were not arrested because no involvement of drivers was established and no information was received that the drivers are also involved in this case. Okay, so the drivers were permitted to leave, but the remainder were all arrested for violating the Ndps Act. Mr. Murugan took down the statements of the apprehended accused and the appellant admitted to the crime. The trial court, after considering all the facts, issued a judgment on December 18, 2009, stating that the contraband was apprehended by officers in the middle of the operation, indicating that the trafficking was not successful and that the accused were acquitted of charges under Section 28 of the Ndps Act. Okay, so basically what happened? The drivers were permitted to leave. The other 4 people were arrested for violating the Narcotic Drugs and Psychotropic Substances Act. Mr. Murugan took down the statements of the apprehended accused. All the 4 accused, they were interrogated and their statements were recorded by Mr. Murugan, and the appellant admitted to the crime. Okay, the appellant, that means Tofan Singh in this case, he admitted to the crime that yes, we were involved in this crime and we have committed this crime. The trial court, when the matter went before the trial court, after considering all the facts, issued a judgment on December 18, 2009. On December 18, 2009, finally the judgment was given by Taran is asking, won't the drivers be categorized under the umbrella of accomplice? They can be if it is established that the drivers were involved and they had prior knowledge what was going to happen in their car. Okay, they can be categorized under the, they can be categorized as accomplice. बात जिस बात तुम इज आस्किंग समझ नहीं आया, क्या नहीं समझ आया? which point you have not understood? Taran, let me answer you first. That they can be called accomplices if it is established that they had prior knowledge of the crime and they were facilitating the crime, the commission of the crime, by providing a car, by providing services to the criminals. Okay, but for example, if you are booking a car, okay, if you're booking a taxi or if you're booking a cab and you are traveling from one place to another, the driver in most of the cases does not have any knowledge what you are carrying with yourself. Okay, same was the case in this issue, same was the situation in this case also. The drivers were booked, their car was engaged, but they did not have prior knowledge what was going on. Otherwise, the NCB would have also arrested the two drivers. Why were they made to leave? Okay, because they did not have prior knowledge of what was going on. Okay, is that clear to you, Taran? So, okay, so Ananya is saying, okay, what happened? See, facts are very easy. There is a resident of Rajasthan, Guddu Singh, who is supplying the narcotics. Okay, there is a resident of Chennai whose name is Kannan, who is procuring the narcotics from Guddu Singh, who is in Rajasthan, right? Who is in Rajasthan. There is one Bapu Lal who is assisting Kannan, who is helping Kannan to procure narcotics from Guddu Singh in Rajasthan. Okay, he assisted. These are three people. Have you understood the role of these three main accused? Of these three people, have you understood? There is one Guddu Singh who is a resident of Rajasthan, who is supplying the narcotics. Who is buying the narcotics? Kannan, who is a resident of Chennai. Who is assisting or helping Kannan in procuring narcotics from Guddu Singh? It's Bapu Lal, who is also resident of Chennai. Okay, after procuring narcotics from Guddu Singh, these three people, while sitting at the back with Tofan Singh in the front and two drivers in the white ambassador car, they left. And on receiving the information and after getting a green signal from the superior officers, Mr. L.S. Arul Das, who was the intelligence officer, NCB intelligence officer, proceeded while intercepting the white ambassador car. Okay, white ambassador car. And after they were caught or they were apprehended, the people sitting at the back, that means Bapu, who was sitting at the back, the two drivers were in front with Tofan Singh, and Bapu Lal, Guddu Singh and Kannan, they were sitting at the back seat in the ambassador car. So the people sitting at the back, they immediately handed out a green bag containing 5 kg of heroin. Okay, and this heroin was supposed to be taken to Sri Lanka by Kannan. Okay, but before that could happen, they were already apprehended by the police or the NCB intelligence officers. Okay, the drivers were permitted to leave because there was no evidence of their involvement in the crime, of they being an accomplice in the case. Okay, but the remainder, that means the Tofan Singh who was sitting in the front and the three people sitting at the back, the remainder, that means the 4 people, Tofan Singh, Bapu Lal, Guddu Singh and Kannan, they were arrested for violating the Ndps Act. So now have you understood? Mr. Murugan, who was also, the cop who accompanied Mr. L.S. Arul Das, he took down the statements of the apprehended accused. They were caught and all the 4 accused statements were recorded by Mr. Murugan. Okay, and while giving the statements, the appellant, who is the appellant in this case? Tofan Singh admitted the crime, that yes, we have committed this crime. While giving the statement to Mr. Murugan, Tofan Singh admitted the crime. The trial court They filed a charge sheet. The matter went before the trial court. The trial court issued a judgment on 18th December 2009, stating that the contraband was apprehended by officers in the middle of the operation. Okay. The trial court held that since the contraband was apprehended before the operation could be completed, and in the middle of the operation they were all arrested, so the trafficking was not successful because Kannan could not take the heroin to Sri Lanka, 5 kg heroin to Sri Lanka, right? And that the accused were acquitted of charges under section 28 of the NDPS Act. Okay, so they were acquitted under section 28 of the NDPS Act. Now before I tell you what is there under section 28 of the NDPS Act, please tell me if the facts are clear to you. Has everyone understood the facts properly? The facts are very easy. There are no complications involved. Okay. Okay. So what is there? The trial court, now listen to me very carefully. The trial court acquitted, indicating that the trafficking was not successful and the accused were acquitted of charges under section 28 of the NDPS Act. That means the operation was not successful and the accused were acquitted of charges. That means the charge sheet that was filed before the trial court, they were alleged to have committed an offense under section 28 of the NDPS Act. But the trial court acquitted all the accused. सारे accused को छोड़ दिया. 28 section 28 and NDPS Act में सारे accused को छोड़ दिया. Okay. लेकिन किस में कन्विक्ट किया? सेक्शन 8C एंड 29 ऑफ द एनडीपीएस एक्ट. बट जिसमें अक्विट किया है, लेट अस फर्स्ट रीड दैट सेक्शन. व्हाट इज देयर अंडर सेक्शन 28 ऑफ द एनडीपीएस एक्ट? सी, punishment for attempts to commit offenses. Whoever attempts to commit any offense punishable under this chapter or to cause such offense to be committed and in such attempt does any act towards the commission of the offense shall be punishable with imprisonment for the punishment provided for the offense. Okay, that means simple that whoever commits any offense, that means it is a simple punishment for an attempt to commit offenses under the NDPS Act. But here, since the operation was not successful, I don't know by what logic the trial court acquitted all the accused under section 28 of the NDPS Act. I am failing to understand the logic behind the judgment of the trial court. Now let us go ahead and read further. However, after convicting the accused persons under section 8C and 29 of the NDPS Act, the court sentenced them to 10 years of rigorous imprisonment and a fine of rupees 1 lakh, as well as another year of harsh punishment for the appellant, all of which were to be served consecutively. Okay, now the trial court acquitted all the accused of charges under section 28 of the NDPS Act, but however, all the 4 accused were convicted under section 8C and section 29 of the NDPS Act. What is there under section 8C and 29 of the NDPS Act? Section 8C of the NDPS Act. Procure, produce, manufacture, possess, sell, purchase, transport, warehouse, use, consume, import, interstate, export interstate, import into India, export from India, or transship any narcotic drug or psychotropic substance except for medical or scientific purposes and in the manner and to the extent provided by the provisions of this act or the rules or orders made thereunder, and in a case where any such provision imposes any requirement by way of license, permit or authorization, also in accordance with the terms and conditions of such license, permit or authorization, provided that and subject to the other provisions of this act and the rules made thereunder, the prohibition against the cultivation of the cannabis plant for the production of ganja or the production, possession, use, consumption, purchase, sale, transport, warehousing, import, interstate and export interstate of ganja for any purpose other than medical and scientific purpose shall take effect only from the date which the central government may by notification in the official gazette specify in this behalf. Okay, now you would have got an idea. Baat Jazbaat or Tum is commenting, but they did the act, so attempt was made. Exactly, that's what I am saying. That's what I am saying. I'm not able to understand why did the trial court acquitted them of charges under section 28 of the NDPS Act, because there was a clear attempt. They were almost about to complete the operation, but before it could be completed, the operation they were apprehended. But there was a clear attempt, but still I'm failing to understand why the trial court acquitted them of charges under section 28 of the NDPS Act. But okay, I'm reading forward now. So they were acquitted under section 8C of the Narcotic Drugs and Psychotropic Substances Act 1985. What is there under section 8C? That if somebody is producing or manufacturing or possessing or selling or purchasing or transporting or warehousing or using or consuming or or is involved in import of interstate import or interstate export or importing into India or exporting from India or transship any narcotic drug or psychotropic substance, then he shall be punishable. This is going to be a crime under section 8C. Okay, this is going to be a crime. But what are the exceptions here? That some of the psychotropic substances are allowed to be imported and exported or transported or purchased or possessed or manufactured or produced. Do you know why? For medical or scientific purposes. Because some of the psychotropic substances and some of the narcotics, they are used in the manufacture and production of medicines, and some of them are used in various scientific institutes for different purposes. So for that purposes, the government has allowed a specific quantity of psychotropic substances which can be produced, manufactured, possessed, sold, purchased, transported, warehoused, used, consumed, and it can be moved from one state to another. It can be imported into India, it can be exported from India, because only for medical and scientific purposes, and only those people can be exempted from such punishment who are properly licensed to do this, to manufacture. Like for example, there are various pharmaceutical industries in the country who are possessing or who are procuring psychotropic substances for making or manufacturing medicines. So basically, making or manufacturing medicines is a scientific or medicinal purpose, medical purpose, and therefore the government has allowed them. So the quantity they can possess has been prescribed under the law by the government, okay, by various rules and notifications and orders and gazettes, okay. And the people who can possess and do such things are properly licensed by the government, okay. No other person who is not licensed to do this can do any of these acts. Have you understood here? Have you understood these kinds of things, these kinds of the situation here? So they were convicted under section 8C and under section 29 of the NDPS Act. What is there under section 29 of the NDPS Act? Section 29 of the NDPS Act states that whoever abets or is a party to a criminal conspiracy to commit an offence punishable under this chapter shall, whether such offence be or be not committed in consequence of such abatement or in pursuance of such criminal conspiracy, and notwithstanding anything contained in the section. Just a second. Whoever abets, punishment for abetment and criminal conspiracy. So section 29 contains punishment for abetment and criminal conspiracy. Whoever is conspiring to do these acts and whoever is abetting such acts. Okay. Whoever abets or is a party to a criminal conspiracy to commit an offence punishable under this chapter shall, whether such offence be or be not committed in consequence of such abatement or in pursuance of such criminal conspiracy, and notwithstanding anything contained in section 116 of the IPC, be punishable with the punishment provided for the offence. Like, for example, whosoever is a party to the criminal conspiracy for committing such offence, like Bapulal in this case, like every one of them was party to a criminal conspiracy to procure narcotic drugs and supply them to Sri Lanka. Like, right? Whoever is abetting, anyone can abet the offense. Okay. No matter where you are and what are you doing, but abatement can be constituted from any place and anywhere at any point of time. Okay. चाहे वो ऑफेंस हुआ हो या ना हुआ हो, इस केस में तो नहीं हो पाया ना, ट्रैफिकिंग तो नहीं हो पाई, बट अबेटमेंट एंड क्रिमिनल कॉन्स्पिरेसी तो हो गई. So they were convicted under section 8C and section 29. Okay. They were convicted under section 8C for procuring and possessing the narcotic drugs and psychotropic substance like 5 kg of heroin. And they were convicted under section 29 of the Ndps Act 1985 for abetment and criminal conspiracy to commit a crime, no matter whether the crime was actually completed or not. Okay, so have you understood here these points? And the court sentenced them to 10 years of rigorous imprisonment. How many types of imprisonments are there? How many types of imprisonments are there? Please tell me. Simple, rigorous, and solitary confinement. Yes, solitary confinement. See, it's you can call it. It's a confinement, which is usually for the condemned prisoners. But basically, there are two kinds of imprisonment. One is the simple imprisonment and rigorous imprisonment, as we have already stated, Taran. Right? Simple imprisonment is an imprisonment without labor. But rigorous imprisonment is qaid ba mashaqqat. That means the prisoner or the convict shall be subject to do some labor. Okay. Like he is going to be involved in the jail course, in the work. Okay, understood. So they were sentenced to, they were sentenced to 10 years of rigorous imprisonment and a fine of rupees 1 lakh, as well as another year of harsh punishment for the appellant, another year of harsh punishment for the appellant Tofan Singh, all of which were to be served consecutively. Acha, tell me, have you understood section 28, section 8C, section 29 of the Ndps Act and the facts of the case? Have you understood the facts of the case and the sections involved here? Okay. Taran has understood. Baat जिस बात हो तुम has understood. Soma Sundaram, Soumya, Ananya, Mehul, everyone has understood. Okay. Now, the appellant who was unhappy and offended by the trial court's decision. The appellant was unhappy with the trial court's decision. Obviously, they were convicted. So, the appellant in this case, he filed an appeal in the Madras High Court, which was dismissed by the Madras High Court on June 18, 2012. As a result, the appellant appealed the High Court of Madras decision to the Supreme Court, against which he went to the Supreme Court in an appeal, in a criminal appeal. Now, issues. Whether the officer investigating the matter under the Ndps Act would qualify as a police officer or not. Now, because there are certain rules of evidence which are applicable and enforceable against the police officers. Like, for example, confessions made to a police officer are not admissible in the court of law as per section 25 of the Indian Evidence Act. You all know this. I am stating this just as an example. Don't take as if this is a part of this case. No, I am just stating it as an example. There are certain confessions and statements that if made to a police officer, they can't be admitted in the court of, they are not admissible in the court of law. Okay. So it was really important to decide this issue, that whether the officer investigating the matter under the Ndps Act, because the Ndps Act is a preventive detention law, and the officers in charge of the investigation under the Ndps Act, whether they would qualify as police officer or not. Because if they qualify for the police officer, if they qualify as a police officer, then all the rules and laws of evidence would be applicable against them also, and same procedure of evidence would apply to them also. But it's a preventive detention law. There are some special provisions under the Ndps Act itself for the conduct of the proceedings and the conduct of the investigation. Okay, so there was a question. Baat Jazbato is asking, why was appellant given another year imprisonment? See, I don't know particularly, because the facts are silent on this case. Right now, the document is silent on this issue. Perhaps everything was happening under his supervision. That's why. Okay. Perhaps the whole crime was being conducted under his supervision. That's why he was the Sardar of all the criminals, of all the accused in this case. Okay. Whether the statement recorded by the investigating officer under section 67 of the Ndps Act can be treated as a confessional statement or not. Now, the statements were recorded by the investigating officer. Do you remember this? We read here that Mr. Murugan took down the statements of the apprehended accused in which the appellant admitted the crime. Now, whether the statements recorded by the investigating officer under section 67 of the Ndps Act can be treated as a confessional statement or not. Can it be treated as a confessional statement or not? Section 67 of the Ndps Act. What does section 67 of the Ndps Act says? We have to read it. Power to call for information. Any officer referred to in section 42 who is authorized in this behalf by the central government or a state government may, during the course of any inquiry in connection with the contravention of any provisions of this act, okay, call for information from any person for the purpose of satisfying himself whether there has been any contravention of the provisions of this act or any rule or order made thereunder. ठीक है, जो भी ऑफिसर सेंट्रल गवर्नमेंट का या स्टेट गवर्नमेंट का सेक्शन 42 में ऑथराइज किया गया है, एनी पर्सन, एनी ऑफिसर who has been especially authorized by the central government or the state government to conduct an inquiry to find out if any contravention exists against the provisions of the NDPS Act, they have the power to call for information from any person for the purpose of satisfying himself whether there has been any contravention of the provisions of this act or any rule or order made thereunder. That means he can call for any information, he can ask or put up any question for satisfying himself to unearth the truth, to find out the truth. Okay, require any person to produce or deliver any document or thing useful or relevant to the inquiry. Any person can be compelled by such officer to produce or show or deliver any document or anything which is useful or which is relevant to the inquiry. C. Examine any person acquainted with the facts and circumstances of the case. Examine any person acquainted with the facts and circumstances of the case. Okay, examine any person acquainted with the facts and circumstances of the case. Whosoever is aware of the facts and circumstances of the case or is connected with the case in any manner, he can be examined by such officer. So basically section 67 of the NDPS Act lays down the powers of the investigating officer. So I guess you would have understood that whether the statement, while he has the power to interrogate the accused under section 67, now whether the statement recorded by the investigating officer under section 67 of the NDPS Act can be treated as a confessional statement or not, because the appellant had confessed his crime. While Mr. Murugam was interrogating all the accused and was recording their statements, the appellant Tofan Singh admitted or confessed his crime. So the question arose that if the same statement had been made in front of a police officer, this would not have been admissible in the court of law as per section 25 of the Indian Evidence Act. But what about a confession made before an investigating officer under section 67 of the NDPS Act? Right? Can it be treated as a confessional statement or not? The issue was this. Now laws. These are the two issues. What are the laws involved in this case? Section 42 of the NDPS Act, Section 53 of the NDPS Act, Section 67 of the NDPS Act. Okay, 42, 53 and 67. We have already read 67. Now let us read 42 and 53. 42 and 53. Now what is 42? Power of entry, search, seizure and arrest without warrant or authorization. Section 42 में, under section 42, power has been given for entry, search, seizure, arrest without warrant or authorization. Any such officer, being an officer superior in rank to a peon, sepoy or constable, obviously a peon or a sepoy or a constable cannot do that. Any such officer of the departments of Central Excise, Narcotics, Customs, Revenue Intelligence or any other department of the central government, including paramilitary forces or armed forces, as is empowered in this behalf by general or special order by the central government, or any such officer being an officer superior in rank to a peon, sepoy or constable of the revenue, drugs control, excise, police or any other department of a state government, as is empowered in this behalf by general or special order of the state government, if he has reason to believe from persons knowledge or information given by any person and taken down in writing that any narcotic drug or psychotropic substance or controlled substance in respect of which an offense punishable under this act has been committed, or any document or other article which may furnish evidence of the commission of such offense, or any illegally acquired property, or any document or other article which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under Chapter 5A of this act, is kept or concealed in any building, conveyance or enclosed place, may between sunrise and sunset enter into and search any building, conveyance or place. That means simply section 47 में द ऑफिसर, जो भी ऑफिसर किसी भी रेवेन्यू इंटेलिजेंस आर्म्ड फोर्सेस का है, या एनसीबी का है, या एनफोर्समेंट डायरेक्टोरेट का है, या सीबीआई का है, जिसको भी एम्पावर किया गया है इस बिहाफ में, सेंट्रल गवर्नमेंट ने या स्टेट गवर्नमेंट ने एम्पावर किया है, उसके पास पावर है कि अगर उसके पास इंफॉर्मेशन आई है कि किसी बिल्डिंग में, इफ ही हैज रिसीव्ड एन इंफॉर्मेशन दैट इन एनी बिल्डिंग और एनी कन्वेयंस, a conveyance means a car or something of a transporting nature, or in a some enclosed place, there are some objectionable material which is kept, like any narcotics or any psychotropic substance is kept, then the officer is empowered between sunrise and sunset. The time is between sunrise यानी कि दिन ही दिन में, only in the daytime, before the sunset, यानी between the dawn and the dusk, he is empowered to enter into and search any building, conveyance or place. He does not need any warrant, he does not need any authorization. Okay, he can enter into such building, conveyance or place. In case of resistance, break open any door and remove any obstacle to such entry. कोई भी दरवाजा तोड़ दे, ठीक है, बेसिकली व्हाट दया डज इन सीआईडी, दरवाजा तोड़ना जो काम होता है ना, कि दरवाजा तोड़ दो. सो इन केस ऑफ रेजिस्टेंस, ब्रेक ओपन एनी डोर एंड रिमूव एनी ऑब्स्टिकल टू सच एंट्री. ओके, seize such drug or substance and all materials used in the manufacture thereof, and any other article and any animal or conveyance which he has reason to believe to be liable to confiscation under this act, and any document or other article which he has reason to believe may furnish evidence of the commission of any offense punishable under this act, or furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under Chapter 5A of this act. Okay, and detain and search, and if he thinks proper, arrest any person whom he has reason to believe to have committed any offense punishable under this act, provided that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, he may enter and search such building, conveyance or enclosed place at any time between sunset and sunrise after recording the grounds of his belief. So basically, under section 42, the officer is all powerful. Whosoever has been authorized by the central government or the state government in this behalf is all powerful to, between sunrise and sunset, he can enter into any place. No, Jazwato is asking, they need a prior search warrant. Under section 42, they don't need a search warrant. That is their power to arrest without warrant or authorization. If the information received is of immediate nature and immediate seizure or search is required, they don't need a warrant. In fact, the normal police is empowered under CRPC to arrest in cognizable cases without a warrant. And also, in cases where the warrant is required, if the police strongly believes, and there is a genuine reason with the police to believe that the seeking of the warrant would waste time and can lead to the destruction of the evidence, the police in such cases arrest any person or search any place without a warrant. Do you know this? Even a normal state police is empowered to do that. And here we are talking about the officers of the intelligence departments of the central government. So under section 42, they don't necessarily require a prior search warrant or an arrest warrant. They can do so on simply receiving an information about such things, and they can make an entry, search or seizure or arrest without warrant or authorization. They can break open any door, they can remove any obstacle, they can enter in and search any building, conveyance or place. They can do anything, arrest the person, interrogate the person. Okay, so these kinds of things can happen under section 42. Have you understood section 42? Now section 53 of the NDPS Act. What is there? Section 53 of the NDPS Act. Power to invest officers of certain departments with powers of an officer in charge of a police station. The central government, after consultation with the state government, may by notification published in the official gazette invest any officer of the Department of Central Excise, Narcotics, Customs, Revenue Intelligence or any other department of the central government, including paramilitary forces or armed forces or any class of such officers with the powers of an officer in charge of a police station for the investigation of the offences under this act. Okay, so basically the officers of these departments means the Central Excise, Narcotics, Customs, Revenue Intelligence or any other department of the central government, they can be given powers like that of an officer in charge of a police station. Okay, the state government may by notification published in the official gazette invest any officer of the Department of Drugs Control, Revenue or Excise or any other department or any class of such officers with the powers of an officer in charge of a police station for the investigation of an offence under this act. So basically an officer in an intelligence officer of the NCB, okay, is invested with the powers like that of a police officer in charge of a police station, like that of an SHO. That means he would qualify as a police officer as per section 53 of the NDPS Act. Now let us read the arguments by the appellants. You just read the case, Ankita. Just read the case properly and you can understand the sections automatically. You don't need to cram them separately. Okay. Arguments by the appellants. There was no mention of the appellant in the intelligence Mr. Aruldos received and his name was not revealed anywhere. So basically the appellant Tofan Singh, who was one of the accused and who in fact got an additional year of imprisonment which was supposed to be served consecutively, he is now making an appeal, and what he is trying to contend before the Supreme Court, he was trying to contend that there was no mention of the appellant in the intelligence. Like when Mr. Aruldos received an information, when he received the information that such and such crime is to be, is to be conducted, and Bapulal and Kannan and Guddu Singh, these three people are involved, there was no mention of the appellant. Tofan Singh's name came I don't understand as an appellant that where did my name comes from. There was no mention of the appellant in the intelligence Mr. Aruldos received and his name was not revealed anywhere. Only three people's name were there: Guddu Singh, Bapulal and Kannan. Why have I been implicated in this case? I am not able to understand. Okay. The appellant was located seated in front, not in the back, with the other defendants on the day of the occurrence. I was sitting on the front seat and not at the back with the accused. Actually, they were possessing the 5 kg of heroin, not me. The narcotics were passed over to Mr. Aruldos by people in the back. Thus, neither the appellant nor the respondent had them. Okay. The raiding party discovered rupees 680 in the custody of the appellant herein, together with 2 second-class train tickets from Shamgarh to Chennai. Okay. The raiding party, that means the NCB officers who raided the car. What they discovered from Tofan Singh, that means from the appellant, rupees 680 in the custody and 2 second-class train tickets from Shamgarh to Chennai. He was about to travel from Shamgarh to Chennai in a second-class bogie. Fourth, there was no evidence of a phone connection between the other accused and the appellant. Tofan Singh had never been in connection with Kannan, Bapulal or Guddu Singh. There was no evidence of a phone connection between the other accused and the appellant. The prosecution's case is based primarily on the appellant's confessional statement, which was reportedly recorded by Mr. Murugan, who also served as the case investigating officer. Now, I was solely convicted on my confessional statement, which I had confessed while recording my statements, while getting my statements recorded, okay, to Mr. Murugan. That is the sole thing on which I have been convicted. The Ndps Act section 67 gives no authority to record confessions or significant evidence that could lead to a confession. Now, section 67 of the Ndps Act, this authorizes the investigating officer to record the statements, but it does not authorize to record confessions or significant evidence that could lead to a confession, that could lead to a conviction. Even if somebody confesses the crime, is he going to be convicted solely on the basis of that confession? That is not the law. Okay, so have you understood the contentions of the appellants here? Now, arguments by the respondents. The appellant made a voluntary confession admitting to his role in the crimes commission. Now, the respondents were trying to say, the state of Tamil Nadu in this case, the state was contending that he had confessed his role in the crime. He admitted to transporting 5.25 kg of heroin from Maniki village, district Mandsaur, Rajasthan to Chennai by the Jaipur-Chennai Express with co-accused Badrilal Sharma, who was dressed in an RPF uniform until they arrived in Nellore, Andhra Pradesh. Following that, Guddu Singh and Bapulal Jain drove them to Chennai in a car. However, they were apprehended by officials along the route. Okay. 5.25 kgs. So, the respondents are trying to say here, exactly, commenting means there was no corroborative evidence. There was no corroborative evidence. He was simply convicted on a confessional statement which he had made while his statements were recorded by Mr. Murugan under section 67 of the Ndps Act. That's it. And that is the biggest question here. Can you get a person convicted solely on the confession he has made? Especially when there are no other corroborative evidence to prove his crime. But the confession was serious. Now listen to what the respondents were contending. What the respondents had contended, the state of Tamil Nadu was continuously contending that his confession was not a joke. He had admitted transporting 5.25 kgs of heroin from Maniki village, district Mandsaur, Rajasthan to Chennai by the Jaipur-Chennai Express with co-accused Badrilal Sharma, who was dressed in an RPF uniform until they arrived in Nellore, Andhra Pradesh. And following that, Guddu Singh and Bapulal Jain drove them to Chennai in a car. However, they were apprehended by officials along the route while they were on the way to Chennai from Nellore. They were apprehended by the NCB intelligence officers. The Ndps Act sections 42, 53 and 67 do not prevent an officer authorized by the Act from conducting a search, seizure, investigation or inquiry into the matter. The state of Tamil Nadu was continuously contending and asserting the power of the NCB under section 42, 53 and 67. Badrilal Sharma, who travelled with the accused appellant, made a confessional statement that was also recorded. Badrilal Sharma's ID card and the appellants and Badrilal Sharma's railway tickets were both on record because they travelled together. All of data demonstrates that the appellant had 5.25 kg of heroin in his hands and was transporting it from Rajasthan to Chennai in order to smuggle it into Sri Lanka. So basically, Badrilal Sharma had confessed the statement, who was the co-accused in this case, who were travelling with Bapulal in a car. So Now here comes the corroborative evidence. You please understand here that here comes the corroborative evidence. But all the corroborative evidence is confined within the confessional statements only. There is no substantive evidence to corroborate what has been confessed. That was the problem. The appeal was made on the ground that we have confessed everything. We were traveling by train. We were fully involved in the crime. Badrilal Sharma was traveling with me. Okay, we had the railway tickets to go back to Chennai. Okay, we traveled from Jaipur Chennai Express from Jaipur to Chennai. We boarded down. We deboarded at Nellore, Andhra Pradesh, and then we boarded in the car with Babulal and Guddu Singh, and we were on a route to Chennai in the ambassador car. That simply means that they were involved in the crime, but there is no other substantive evidence to corroborate what exactly was confessed. Okay. Judgment. The appellant had already served more than 9 years of his sentence under the Ndps Act, despite the fact that he had been sentenced to 10 years by the additional special court. In these circumstances, the suspension of additional sentence was deemed appropriate pending the outcome of this appeal by the bigger bench. The appellant was to be freed on bail after providing the trial court with security in the amount of rupees 50,000 and 2 sureties in the same amount. Now, Jazbadutum is asking, who is Badrilal Sharma? He is also one of the co-accused in this case. Okay. See, don't try to, spread the issues here. Who is Badrilal Sharma? Badrilal Sharma is also one of the accused in this case. Why this is so confusing? I don't understand why this is so confusing. You simply have to understand this law, that Badrilal Sharma is also one of the co-accused in this case, and that means the Tofan Singh was with Badrilal Sharma. That's it. He was traveling. He was traveling in a train. He had second class train tickets for both of them, and he was about to travel. Okay. And was they both were involved from transporting 5.25 kg of heroin from Rajasthan to Chennai in order to smuggle it into Sri Lanka. Okay. He was not mentioned before because the case spreads over certain angles, and we cannot discuss every angle in 1 hour. That's not possible. Okay. What do you think? The case is just what we discuss every day in 1 hour? That's not the case. We consolidate it on certain points and then we discuss it. Okay. So let's not get into that different issue. Who is Badrilal Sharma? Where does he comes from? And what was his involvement in the crime? Here the question is regarding the guilt and innocence of Tofan Singh. The judgment is simple. Okay. The appellant had already served more than 9 years of his sentence under the Ndps Act, despite the fact that he had been sentenced to 10 years by the additional special court. Now already he had served 9 years of his sentence under the Ndps Act, and he was sentenced to 10 years by the additional special court. In these circumstances, the suspension of additional sentence was deemed appropriate pending the outcome of this appeal by the bigger bench. The appellant was to be freed on bail after providing the trial court with security in the amount of rupees 50,000. Now the appellant was freed on bail. Okay, he was given bail on the amount of rupees 50,000 and 2 sureties in the same amount. As per the October 2020 judgment, the appeal was directed to a larger bench. It was concluded in October 2020 that Section 25 of the Indian Evidence Act would only apply to a police officer or an officer who exercises all the powers of a police officer, including the power of filing a police report under Section 173 CRPC. An officer under the Ndps Act does not have the power to file a police report under Section 173 of the CRPC. So basically, Section 25 of the Indian Evidence Act would not apply against the officer under the Ndps Act. Okay, this would simply apply against the police officer having the powers of the police officer. Okay, like who can file a final report under Section 173 of the CRPC. The Ndps Act where the provisions of the CRPC does not apply to any inquiry investigation except as provided therein. It cannot be held that the officer has all the powers of a police officer to file a report under section 173 of the CRPC. In the trial of an offence under the Ndps Act, the statement recorded under section 67 cannot be used as a confessional statement. Okay, so basically in the trial, on the Ndps Act, the provisions of the CRPC does not apply. Okay, so an officer under the Ndps Act cannot be called or does not qualify as a police officer because he does not have the power to file a report under section 173 of the CRPC. Third important observation was that in the trial of an offence under the Ndps Act, the statement recorded under section 67 cannot be used as a confessional statement. It cannot be used as a confessional statement. The officers empowered by section 53 of the Ndps Act are police officers within the meaning of section 25 of the Evidence Act. Any confessional statement made to them would be forbidden by section 25 of the Evidence Act and could not be used to convict an accused under the Ndps Act. Okay. But still, after observing that Section 25 of the Indian Evidence Act is only applicable against the police officers, still the larger bench of the Supreme Court observed that the officers empowered by Section 53 of the Ndps Act are police officers because all the powers of the police officers have been given to such officers by Section 53 of the Ndps Act. So they would also qualify within the meaning of section 25 of the Evidence Act. And so therefore any confessional statement made to them would be forbidden by section 25 of the Evidence Act and could not be used to convict an accused under the Ndps Act. Okay. Now your questions are most welcome. Any question? I guess you don't have any questions. Either you have understood the case fully or you have not understood it. So Baat Jazbatum is asking, so the court did not accept for the admission as a substantive evidence. Exactly, the court did not accept it as a substantive evidence, and especially it cannot be a ground, it cannot be the sole ground for conviction. And already he had served, 9 years already in prison. And also the admission or the confession cannot be the sole ground for the cannot be admissible in the court, because section 25 of the Indian Evidence Act would apply. Confession made to a police officer would not, it's not admissible in the court of law. Section 25 of the Indian Evidence Act is will be applicable here, because under section 50, under section 57 or 53, sorry, under section 53 of the Ndps Act, they qualify as police officers, and so section 25 would be applicable on them also. So any confession made to them would not be, cannot be the sole ground for conviction. No, Ankita, this was not the issue here. I don't understand why I really fail to understand your questions. This case is about the innocence and guilt of the appellant in this case. Simple. There are some provisions of law involved, some questions of law that were supposed to be discussed in the case. It's not about the proper authority. It's not at all about the proper authority. NCB is all empowered to investigate such cases of narcotic drugs and psychotropic substances. Who else then will investigate such cases? Normal police. So I guess no more questions are there, and I am then signing off. Hope to see you tomorrow with a new judgment. Okay, till then, all the very best. Bye bye.